Okay, it looks like we're live. Can you hear me, David?
Yes, I can.
Great, fantastic. So the topic of the day is 20 ways that lazy lawyers can lose winnable cases. So I'm just
Okay.
going to turn it over to you and let you take it away.
All right. Well, not to disparage any other attorneys, but I think you should make sure your attorney is thinking about a number of things. To start with, they have to look at the stop. Police officer needs an articulable basis to stop you. Everyone knows that you just can't stop anyone except for checkpoints, which is another subject. And explore the basis for that stop. And whether, and there's a couple of bases that are very common, like weaving. You have to look very closely at that because sometimes officers say you're weaving when you're not actually crossing the line. You're just moving around in the lane, which people do sometimes, and it's legal. I would think another one, very common issue about a stop, we're talking about stop still, is an anonymous tip from a drunk driver, something called a READY report, which stands for report every drunk driver immediately. Those calls are often kept anonymous, and so that's not a sufficient basis for an officer to formulate a reason to stop. He needs to make his own observations as well to corroborate that. Otherwise, we could just call on anyone we saw, and so the person has to have some credibility, and an anonymous source does not have that. The next general heading would be under invalid arrests. The officer has to have probable cause to make an arrest. If you just can't make an arrest of anyone you want, and so you should be asking your lawyer, how will you challenge that? Because you may have heard of a suppression hearing. That's exactly what this is if you prove that there's no reason or probable cause to make the arrest, then anything that's found as a result of that, what is then an illegal arrest, is suppressed by the judge. So that's a very important part of any DUI that an attorney should look at. I think after the person's contact by police, the question is going to be, how is that probable cause formulated? And so the officer's observation, lawyer, first of all, almost every single one of these cases is going to have odor of an alcoholic beverage checked. And of course, everybody knows alcohol doesn't have an odor. Most people know that. It's the things that are used to make the alcohol that you can actually smell. That's a very common thing. So you look at that. Also, bloodshot and glassy eyes, that's always seen. And I think most people generally have that most of the time. The good question your lawyer should be asking is, what does the client's eyes normally look at? Maybe there's a booking photo where you can look at their eyes and see, is that really true that they were red and bloodshot? Usually when I'm cross-examining an officer, they work nights and they come into court and their eyes are bloodshot. So that's something they should look at. Slurred speech is very common as well. Many people have accents or or speak other ways. Other people have speech impediments. Sometimes people are nervous or they're just tired, and that can affect your speech. So you need to look at usually slurred speech is going to be a box they check, and you need to look at that. Now, if the officer conducted field sobriety tests, which we also call roadsides, these are the traditional, walk the straight line kind of tests, you need to look at those. First of all, a lawyer might consider challenging all those roadsides because some people aren't necessarily qualified to give them. Other things are unreasonable, and you should be looking at those from every single facet through extreme detail. Because that's the most interchange the officer have with the person who's charged. So that's important. I would object to them coming in a jury trial. Most judges are going to allow that, but at least you can make a point about credibility, maybe attack that somehow and find more about the officer's accreditation and training. I think that there are many ways, that there's also a pamphlet that the officers use, and your lawyer should have that. They actually use something produced by the National Transportation Safety Board, and they have a manual that they're using. So you need to be familiar with that. Your lawyer should be. I would say, and you can challenge basically their ability to make that determination. I think also there's questions about people's health going into it. The recommendations for the National Health and Safety Board are that a person shouldn't be given these tests if they're over 60 years old, or if they weigh over a certain amount, or they have any other physical impairment which impairs their balance. And so the officer will often testify, well, I asked him that question, and he said he didn't have any things that would interfere with his taking the test. Of course, the person who answered that question didn't know what they were going to be asked to do. So it's kind of like, you know, I need to do some tests. Can you do them? And the person says, I think so. And they say, well, then you didn't tell me. But that's really turning on its head. The question is whether that's been known or not. And if your client actually has physical impairments, then those are reasons why the test should not be admissible before a jury. I think where the tests are done are important. Oftentimes the weather is an issue. It can be very cold, or you're on the side of a freeway and there's cars going by, or it's poorly lit, things of that nature. There's a horizontal gaze nystagmus test, which sounds confusing. It's when they shine a light on an object, usually a pen or their finger, and they move it around. And that's a test that's often done. There's 3 tests for each eye, a total of 6 tests. Judges generally let that in, but I think you should always be challenging that because it's a scientific test, and these officers aren't really scientists. They're not eye doctors. Just because somebody says, yeah, you know how to do this test, maybe that shouldn't come in. Also, there's other causes of nystagmus. Some medications cause it. Some people have that condition naturally. So those are other questions that your lawyer should be looking at. Anything that's not one of what are called the standardized roadside tests, and those are the standard walk and turn, the one leg stand, and the horizontal gaze nystagmus. Anything outside of that shouldn't be used. For example, alphabet, that's one that's not accepted anymore under the federal government anyway. And you could maybe argue to a judge that the court shouldn't hear that either. Your lawyer also should be looking at what kind of test was given. Was it a first of all, there's a handheld breath test. That's called the portable breath testing device, or a PBT. Now, that's inadmissible at trial, so you certainly should be stepping up and not letting that happen. There's a second breath test that's done at the police station. It's a different one, and that's the actual breath test. And your lawyer should be asking for a maintenance log on that, because that's very important. It should, how to describe it? It should tell you that the machine is in good working order, and whether it's been properly maintained, and how many tests have been given on it, and whether there are any codes that flashed that required extra servicing. So your lawyer should be asking for that. I think in addition to that, sometimes breath tests themselves, it's not as accurate as they say it is. There's also a formula they use to derive the actual amount. So a lot of lawyers have problems with that, with the science in general. But something that happens with test results, either blood or breath, is that that it's actually testing their blood alcohol content after they were driving, sometimes as much as an hour, hour and a half, almost 2 hours afterward. And of course, your blood alcohol changes over time. So in that time, you could have gone from legal to illegal, from not impaired to impaired, or from impaired to intoxicated. So that your lawyer should be looking at that. I think unusual circumstances, like when there's an accident, that's a big deal, because the cars are usually stopped. Everyone's standing outside of their cars. Officers often generally make the assumption, well, you must be the driver of the car. And oftentimes they don't see the driver, and no one's seen the driver. And so, especially if it's a single car accident. So that's something I think that you need to look at. I'd say generally, your lawyer should be looking at these cases with fresh eyes from every conceivable angle. Most people have, I'd say that the weakness for most people, and sometimes lawyers, is you look at so many of these and you hear so many of them, that you don't look at that and ask a lot of little questions. The details are where a winning case is found, and you have to know those details, and you have to narrow them down and find out which of them can help you in your case. And that's what your lawyer really should be looking at. And you shouldn't be accepting people's just generalization, because the person who's stopped from driving, they don't necessarily know a lot of the other details. And then some details no one's ever asked them about. It doesn't show up in the police report, and the officer and their lawyer doesn't ask them about that. And I usually ask them, well, how much did you have to drive? How did you feel? Did you feel okay? Is there something wrong with the test? A lot of people don't ask that question, and that should be the first question: is, were you okay? Did you think you were okay? So that's a pretty quick run through of what I think a lawyer should be asking and should be aware of. And I think you should feel like he's asking you an awful lot of questions, and a lot of them you're not going to have the answer to, but he should be asking them and trying to get answers to them, because those answers, that's where a case can be won or lost. And some cases you can win them, but if you don't flesh that out and bring that forward, then you're going to lose.
Great. Fantastic. Well, thank you very much, David. This has been incredibly educational, and I look forward to our next meeting.
Okay, we'll talk to you then.
Have a great day. Bye-bye.